Okay, I think we'll make a start there. So good afternoon, everyone. Thank you ever so much for your time for the next 45 minutes, joining us for a really interesting and timely conversation all about the basics around green claims. My name is Richard Waters. I head up the strategy team at Eunomia, and we'll just spend a few minutes doing introductions, talk about the agenda, and then we'll get into the content. My colleague Michael will take us through that shortly. So, the agenda, after a brief introduction, Michael will then talk about what the new rules are and how they affect different companies. We'll then have a quiz. We can just try and think through whether certain claims might be compliant or not. Just reflect on some next steps, useful links to allow you to take the next steps forward if they're relevant for you and your organisation. And then finally, with a bit of luck, we'll have time for a Q&A. By the end of it, we're focusing on the EU and UK, so hopefully you'll get a much better understanding of all the relevant legislation that impacts or could impact you around green claims, and then understand also what you can and what you can't claim. There's a Q&A function built into this Teams webinar, so you should be able to see that at the top of your screen. So if you do have any questions, if you pop them in there, and then again, time permitting, we will hopefully be able to pick up some of those. I believe you're able to upvote ones that you think are relevant, so rather than typing the same question again, if you see one that feels similar to what you would be interested in asking, if you upvote it, then we can ideally focus our time on those instead. Okay, so a lot of you already know me, you may be existing clients, but for some of you it might be a new organisation to you. So I just thought I'd spend 2 minutes introducing a little bit about Eunomia. We are exclusively based around the environment, have been doing so for 25 years. We focus on 3 key themes: the circular economy, low carbon and the natural economy. We're very global and multinational in our nature, with a headquarters in the UK, but we also have significant operations in the US. We've got an office in New Zealand and Brussels as well. As I mentioned earlier, I head up the UK strategy team and also actually run our London office. I'm delighted today to be joined by one of our senior consultants, Michael. If you'd like to introduce yourself, please.
Thanks, Richard. Yeah, I'm Michael Kirk-Smith. I've been at Eunomia for about 5 years now, specialise in life cycle assessment, recently focusing on reusable packaging claims and more recently green claims. So I'll be doing most of the talking at the webinar. I'm based in the Bristol office. I'm originally from Liverpool, if you're trying to place my accent over this call. Saves you from doing that.
Thank you. And then just very briefly again, just to give a tiny bit more context to Eunomia on the next slide, please. A little bit more information about us. Here we go. So yeah, as I said, we've been going for 25 years or so. So we've done literally thousands of different projects. We've got very deep expertise around policy. We've got some very specialist knowledge which is relevant to this topic. We work across all the different private sectors, but also up and down the value chain. We're very unbiased in our the way we research stuff, so we're respected for our opinions, and we've built an awful lot of tools and capabilities to allow us to model things as well. And then just a final slide before we get into the content here, just an example of some of the organisations we work with. So what we find really exciting and really useful actually for our clients is that we work both with governments, supranational governments, with NGOs, with local governments and private sector organisations, so we can see all of these complex systemic issues from different perspectives, which means we can be really quite credible in the opinions that we offer up. Okay, we'll start quickly with a poll just to help us really about your main reason for attending the webinar. So hopefully on your screen, I think there's going to be a pop-up that you can see, and I think there's 4 options. If you've just got a second just to click on the one that feels closest to the reason that you're attending, that just helps us, please. I'll give you just 20 seconds to do that and then we'll crack on. I'll give that 5 more seconds. And I don't know actually if you can all see the results. I think what I can see here is that over 80% of us know a bit about green claims and want to learn a little bit more. So for the vast majority of us, I think this content is going to be really, really specific. And then for the other people as well, hopefully there'll be a lot to learn. And for those that have specific questions, hopefully we'll get a chance to answer them. So thank you for supporting that. And now I think we're going to crack on with Michael. Take the lead. Thank you.
Cheers, Richard. Yeah, that couldn't have worked out better. That was a good response to that poll. And we've got up to 90 people, which is, again, a good turnout for the webinar. So I want to start talking about greenwashing in broad terms. I've put some text in the top right here from the Green Claims Directive, which we'll talk about later, about the definition of greenwashing, that it's about giving a false impression or misleading information about how environmentally friendly a product or service is. It's not always a lie necessarily, but intentional or not, it does slow down real progress. And I just thought it was important to remember the bigger picture before we start. For individual companies, this is about risk, but for society in a more broad sense, it's about driving environmental change, and greenwashing slows that down. So let's move on to the new and upcoming laws about greenwashing. I'm going to talk about 3 of them here. It's not the whole landscape, there'll be a bit more on that later. It's just the new and upcoming stuff. So the top 2 in this slide are European and the bottom one is UK, and the colours indicate whether or not they've been passed or they're still under review. Starting at the top, the Empowering Consumers for the Green Transition, or EMCO, as I'll refer to it in this presentation. So this has already entered into force in 2024, so there's no more debating about the text. And on the 27th of March, just gone, that was the deadline for member states to transpose this into their national law, and that prompted a 6-month countdown up to the 27th of September this year for the rules to apply in those member states. We'll talk a lot more about the details over the next few slides, but the key thing I want to highlight here is that EMCO is a general framework and it focuses on what is not allowed. You then have the Green Claims Directive, and it's a bit confusing when you start looking at this because EMCO is a directive about green claims, but it's not the same thing as the Green Claims Directive. The Green Claims Directive has not entered into force. It's paused right now. They can't agree on the text. Similar to the omnibus situation, some people are saying it goes too far and it's too anti-business. I'm not a Brussels insider myself. We do have, as Richard said, people in Brussels at Eunomia. If you're interested in talking about kind of the progress of that currently. But if it does get approved, then the Green Claims Directive will give more specific guidance on what companies can say. So what is allowed. So for example, it will specify the methodologies you need to use when you make a carbon footprint claim, that more specific element. In the UK, at the bottom, we have the Digital Markets Competition and Consumers Act from 2024. I think you're more likely to have heard of the Green Claims Code, possibly, if you're on this call. That was published in 2021. The DMCCA is essentially what gives the legal teeth to the Green Claims Code. It basically gives enforcement powers to the Consumer Markets Authority rather than the courts, so they can rule against the companies who breach the Green Claims Code. It's similar to the EMCO directive in that it's general and that it talks about what's not allowed. So to sum up, EMCO and the Green Claims Code general and currently in place. EMCO is a bit more specific. We'll talk more about that later. And the Green Claims Directive will be even more specific again, but that's still being negotiated. We're not going to focus that much on the Green Claims Directive in this presentation. So first pop quiz, if anyone knows who this is, just from seeing him, you know, go on Who Wants to Be a Millionaire. Your trivia knowledge is exceptional, but you might be able to guess from the context that we're talking about here. So this is Clark Stanley, the quintessential snake oil salesman. If you haven't heard that phrase before, we use it when we're talking about someone selling a product that's too good to be true. In his case, selling rattlesnake oil and claiming that it cures rheumatism and toothache and ankle sprains. He's the quintessential snake oil salesman. In the early 20th century, the Senate in America passed an act called the Pure Food and Drug Act, and that limited what companies can claim about their products, and that led to Clark being prosecuted in 1916, fined, and ultimately led to the protection of consumers. So the point of showing Clark, as well as it just breaks up the presentation nicely, is that it shows that consumer protection is nothing new, and even greenwashing protection is not totally new. All that the EMCO directive is doing is making amendments to two existing directives. You can see that on the slide here if you follow the arrows. It's making amendments to the Consumer Rights Directive. That's more to do with kind of the repairability and durability aspects of EMCO. And it's making amendments to the Unfair Commercial Practices Directives, which is more relevant to the generic green claims aspects of EMCO. We're going to talk more about the aspects of EMCO on the next slide. The Green Claims Code in the UK itself ultimately derives from the UCPD. It's from back when the UK was in the EU. We transposed the UCPD into our national law, and then the Green Claims Code is our kind of bit more specific guidance for how to stick to that. Because of this, the Green Claims Code is broader in scope than the EMCO directive, because the EMCO is just amending certain parts of the UCPD. But that doesn't mean that the UK, we've covered more than the EU. We've basically covered the same stuff, but the EU now has this extra level of clarification thanks to the EMCO directive. So what do these laws and guidance documents actually prohibit? What is a non-compliant claim? The big one is unbacked generic green claims. I've put the legal text at the top there from EMCO that it's banning claims without recognized excellent environmental performance. That's the backing element of it that you need. We'll talk a lot about that phrase, what's going to come up in this presentation. I've listed some of the specific terms from the directive. So phrases like eco-friendly, green, environmentally friendly are things that you need backing for. It's a very complete list. There's probably some missing. Good for the planet. I see that a lot. But to be honest, they're not really missing. This is not meant to be a complete list. These are just examples to help companies understand what they can and can't do. The Green Claims Code in the UK is ultimately similar, although it doesn't provide such an extensive list of examples. So this is the big focus, especially for EMCO, is going after these generic green claims. And the key thing is it's not an outright ban on these claims, it's just banned without backing. Next, these are less the focus of this presentation, but I'll cover it for completeness. So first up, companies can no longer include a sustainability label unless it meets quite stringent new requirements. So it's either got to be a public authority ran label or one that has third-party verification. It must be publicly available, open to all traders, ongoing monitoring. There's a long list of new requirements that labels need to fulfill. You might have seen that B Corp have just recently changed. They've added a third-party verification service to comply with this. If you're a B Corp. The Green Claims Code doesn't cover this at all, really, other than saying about how third-party certification can help boost consumer trust, but it's not as prescriptive. Second up, a lot of the clauses in the EMCO directive are about this, even though we're not focusing on it in this presentation, is about durability and repairability. So this includes things like banning planned obsolescence, telling users that you need an upgrade when you don't really need it, telling them you need to get repair when you don't really need it. Again, the Green Claims Code kind of covers this in its broad framework, but it's not nowhere near as specific. So it doesn't kind of empower consumers to the same extent. It doesn't make it as easy for them to hold companies accountable for these things. At the bottom, I've highlighted one specific example that I find really interesting here. Perhaps I've got a background in organizational carbon footprinting as well. So this is about product carbon footprinting, but it's there's crossover. So with carbon neutrality, the wording is a little confusing to me in the EMCO directive, but I've pulled out this quote from the directive, which I think is really clear. I'll just read it out. So it says, such claims should only be allowed when they are based on the actual life cycle of the product in question and not based on offsetting of greenhouse gas emissions outside the product's value chain. So for me, that basically means climate neutral as we've known it for the past 15 years or however long it's been around is not being allowed anymore. The only climate neutral claims that are allowed is insetting or kind of value chain mitigation, something that's more akin to what you can do with the SBTI for your residual emissions, for those of you who are familiar with that. I think there's a bit of detail to be ironed out there, but I think that text is clear, and I think that's quite a big deal for some companies who make carbon neutral claims, and presumably the offset markets, it would be a fairly big deal to them if it is enforced as the text implies. The Green Claims Code, again, is a little less prescriptive and a little less punitive in this sense. So in the UK, you can still claim carbon neutrality based on offsets. You just have to say that that's what you're doing. So in the UK, we could still get flights. We could still get EasyJet claiming to be carbon neutral, whereas presumably that's going to be very difficult in Europe. So as promised, we're now going to talk about how to back green claims, how we define that recognized excellent environmental performance. The wording itself is obviously broad and leaves the door open to greenwashing, but the directive provides much more specifics in the text on how to do that, and there are 3 ways. So the first way is the EU Eco Label. This has been around for a long time. A lot of you will probably be familiar with it, but for those who aren't, to get an Eco Label, you essentially have to fulfill a set of criteria across a range of environmental impacts, and you have different ones for different product categories like cleaning products, packaging, textiles. So for a t-shirt, for example, to get an EU Eco Label, you need to meet criteria regarding how you farm your cotton, minimum energy efficiency standards for your kind of looming machines in your factories, whether or not the colors run when you wash it. So it's ticking boxes and meeting a kind of minimum performance standard across the whole life cycle. Number 2 is kind of national or regional versions of the EU Eco Label. So similar to the EU Eco Label, but reflecting the priorities of those member states. The third point is a bit longer and more complicated. The key bit is that it's talking about schemes that are in accordance with union laws, and it's about a specific environmental characteristic, so energy or climate, rather than broad eco labels, which are about multiple characteristics. They often give the example of EU energy labeling regulation in the directive, and in the FAQ document, they often cite that as the example. I think it is tricky for companies to figure out exactly what this means. They don't give a full list, even though presumably there is a full list of schemes that meet this requirement. A lot of the union laws are about banning something like REACH. They're not necessarily about establishing a kind of higher echelon of performance like the energy labeling regulation is. And just to reiterate about all these, we're just talking about EMCO here, and this is where I think EMCO deviates perhaps most significantly from the Green Claims Code, in that it's setting up a specific set of options by which you can back your generic green claims, whereas the Green Claims Code is not specific about that. So yeah, it is really specific. And you might be thinking, hold on, I've done all these LCAs, done my carbon footprints, I've got all this evidence to say my product's great. Why can't I shout about that? Why do I have to have this EU Eco Label? And I think the key point here is that EMCO is just focused about those generic claims. You can still shout about this stuff, but those would be a specific claim. And that's really where LCA comes into this. So for EMCO, all those eco labels we saw on the last slide and are on here, you don't need an LCA for them. If you conduct an LCA, and there's lots of good reasons to conduct an LCA, I might be biased because I'm an LCA practitioner, but there are a lot of good reasons to conduct an LCA. They will give you a lot of the data you need to do these eco labels, but it's not a requirement of the eco labels. That's more for the specific claims. And that's where the kind of UCPD that we saw on the slide with the arrows comes into it, the kind of parent directive to MCO and the Green Claims Code. They're broader and they cover environmental claims that are comparing a product to another product, for example, or a product to the market average. And both of them will say in the text that life cycle assessment is a good way to do that. But they're not super specific. The Green Claims Directive is what's going to give the specifics on how to make those specific claims, like what are the specific methodologies to use, or the kind of the nitty-gritty, if you like. Apologies, more to myself than anything, but this is another really text-heavy slide. I've got a lot of legal text here, so hopefully it's useful for people wanting to know the details of the directives and the guidances. I'm not going to read all of it, I'm just going to pull out the important bits. But this is where I want to talk about what I see as perhaps more grey areas. I can imagine being more difficult for companies to navigate. So firstly, the use of imagery. The MCO, I would say, is unusually a bit more relaxed than the Green Claims Code here, at least on paper. So if you're in Europe, imagery without text cannot be considered a generic claim, because by definition, a claim is oral or written. But then it does state that imagery should be truthful and not overstate the benefit achieved. So the imagery should be truthful, but it can't itself be a claim. So for me, it's hard to square that circle. That's a bit of a grey area. If you're in the UK, it doesn't specify this. It says that language or imagery can constitute a claim. It also has this interesting clause, which I'm going to read out here. It talks about how a company responsible for a significant amount of emissions or other environmental harm, it calls them out and essentially says they shouldn't be misleading by their use of imagery and formatting and things on the packaging. I don't believe those industries are specified in the code, but most people will assume they're talking about oil companies, aerospace, fracking companies. We'll touch on this a bit later on with one example, but it's worth saying, I think as well, that to my knowledge, no company in the UK has been ruled against solely on the imagery they've used. Put in the comments or the Q&A if I'm wrong there, but yeah, it's in the text, but it is clearly difficult to enforce. Second up is existing brand names. The Green Claims Code and MCO are quite similar in this regard. So MCO clearly states that a name alone could constitute a green claim. So as with any claim, they have to demonstrate an excellent environmental performance. However, and this is where I think the grey area is, that excellent environmental performance is about products, not companies. So does every product need an eco label if that company is selling it? It's not totally clear for me from the text how a company could do that. I've pulled out a few examples here which I think are interesting to think about whether they would be compliant or not. First one is a bit UK specific, apologies, but there's a pub chain in the UK called Green King, and I think it's safe to say that they are not, reading the underlying text, they're not likely to create an environmental association in the consumer's mind, even though they have the word green in their name. Whereas for Ecover and Ecolab, I just pull these out randomly, but perhaps it's not as obvious. Ecolab, it does sell a lot of products which mark themselves on their sustainable credentials, but possibly less so than Ecover, which even has the imagery within its logo name. They would clearly need to demonstrate excellence, but how exactly would they do that under these rules? It's not entirely clear. What time are we on? I think I'll skip this last one. I've posted an article on LinkedIn about this. it's essentially talking about a kind of lack of clarity in the EMCO directive about climate-friendly claims and how whether you could make a climate-friendly claim even though none of the kind of eco labels are specifically about climate. They're about broad eco criteria. But yeah, if you're interested in that, you can add me on LinkedIn. There's only one, Michael Kirk-Smith, as far as I'm aware. Okay, before the quiz, I want to talk about the risk aspect of this. So I split the risks in the top left here into 3 categories. Financial penalties. So a company might get charged a fixed fine or a percentage of their annual turnover. Individual countries set the minimum level of the fine, set the exact levels of the fines. The EU just sets the minimum. And I've just given one example here of this kind of 4% of global turnover in the EU or 10% in the UK. That would obviously be a huge sum of money. I'm not aware of any case going that far. Usually it's settled at a smaller amount or before it gets to fines. But that's not to say that it can't happen, especially with EMCO now kind of empowering consumers more. The second one is name and shame or your reputational risk. One interesting point here is in the UK, the CMA will actually, the Consumer Markets Authority, they'll actually say when they're investigating you, even before a ruling is made. So you'll be on their website along with all the other claims that they're investigating, potentially tarred with the same brush. And there's an interesting question here about kind of greenwashing and greenhushing. You want the transparency from the CMA of what they're looking into, but you don't want to put companies off making any green claims. So they have a tricky line to toe there. And then finally, injunction. That might be obvious. You just remove the ad if you get ruled against. In terms of how they get enforced, the key point for me is just that it's not like a parking ticket. You won't just be sent a letter through the door with a fine to pay. In the UK, the ASA, Advertising Standards Agency, they seek out things to investigate in 2 ways. Well, things that get investigated arrive there 2 ways. One is proactive. So they will do thematic investigations. So they look at aviation sector or the energy sector. And the other is reactive. They'll respond to individual complainants that come in from the public or competitors. They'll then deliver a judgment. The company get a chance to respond. The ASA give their final ruling based on the company's response. And then they get the chance to take down that ad. Or if they don't, they face a fine, ultimately. So, quiz time. With all that knowledge you've got now, we're going to look at a few examples, and John is going to flash up a compliant or non-compliant. It's going to be quite quick. So I'm going to flash up an image of an advert, and then you're going to have an educated guess, or you might know the answer, if it's compliant or not compliant. So first up, this first example, I've picked out Coca-Cola here. I could have picked out Pepsi or many soft drinks companies. Here's an ad claiming I'm a 100% recycled and recyclable bottle. Is this ad compliant or non-compliant? Not sure if that disappears. I'm just going to move on. So the ad is compliant. The key is the asterisk here. Oh, an incredible split. But understandable that many people got that wrong. So the key is the asterisk here. They state in a way that has been judged as readable to the average consumer in the small print. This statement that I've pulled out in the red, that the 100% recycled content excludes the cap and label, which are not recyclable and made of 100% recycled content. You might remember this being in the news a lot 3 years ago. Eunomia actually contributed the technical evidence towards the Client Earth investigation into this. And following this, the ASA in the UK, and I think possibly in similar cases in other countries, ruled that the ruling was upheld and the soft drink companies had to add this caveat. So now it is compliant. It previously was not. This is a specific. It's worth saying this is a specific claim, which, to my understanding, would not be impacted by MCO. It falls under the more generic laws like the UCPD in Europe or the Green Claims Code in the UK. Second is an advert from Shell Energy, which appeared on LinkedIn about 2 years ago. It shows sunny pictures of Italy, fields with solar panels, and the text mentions how they're working with Baker Hughes, a company to help them reduce their emissions. An individual complained that it was misleading, giving a misleading impression of the overall environmental impacts of Shell's business. So what was the final ruling? I'll move on. Compliant again. If you thought I'd do alternating answers, not the case. So again, ACE found this was compliant. They determined that it was clearly focused on their work with one client, that it wasn't trying to represent and give a misleading impression of the company as a whole. Yeah, that was the key determining factor in their ruling. And Shell's been targeted a few times for greenwashing ads. They're very well practiced at how to navigate them, and we could probably learn a lot from them. Companies could. So another ruling which was not upheld, so it was compliant, was this advert. I certainly remember this on TV. A lady in red overalls walking through all these scenes with wind turbines and largely talking about all the good stuff Shell was doing. Clearly talking about Shell as a whole, and it was on television, not a business to business claim like the Baker Hughes one. But they still ruled it was compliant because they had the small print in there. They had a scene that showed the percentage of what their business was renewables and what was oil and gas. So a lot of claims that are upheld that are compliant. Sorry, a lot of claims that are upheld that are not compliant about omissions of information. So giving caveats and asterisks is a way a lot of companies get around this. I'm going to skip past that one because we're running low on time. Third up is H&M's conscious brand range. So third and final poll, there's clear kind of green imagery being used here. The term conscious is used. It's not eco-conscious, as is mentioned in the new MCO directive. But this was ruled on in a European country. Was this found to be compliant or non-compliant? Yay or nay? Okay, I'm going to move on. See the answers come in soon. Yeah, most people got that right. But it is also confusing. So understandably, people did not get that right. So it was found to be non-compliant under the Norwegian Marketing Control Act. Obviously, Norway not in the EU, but they followed the EU's laws. They ruled because there wasn't sufficient evidence provided. They didn't have the backing to the labeling scheme, and they didn't like the labeling scheme. They used the Hague MSI. So we could do a whole webinar on this case. So Norway made that ruling even without the MCO directive in place. So presumably when the MCO directive is in place, it's going to make it even easier for consumers to bring action against similar claims. But arguably even easier for brands to navigate not getting caught up in that. So there's a bit of a two-way street. And interestingly, this wasn't the case for the US. There was around the same time, a student in the US brought a similar case to H&M, and they were not found guilty. I shouldn't really use the word guilty in this sense, but because they don't have the same consumer protection laws in place. That's it for the quiz. So I'm going to just close off here by talking about the next steps that you, as a company, should be taking. Oh, I got a thumbs up. Thank you. Whether you're a retailer or a manufacturer or brand or both or multiple. So the first step would be to review your existing claims. So review these against what you've learned today, read the document yourself or get an expert to do it for you. I think for retail in particular, this is going to be quite complex because you're responsible not only for your own claims, but technically for the claims of all the products you're selling. Second, if you need to, gather evidence to back up those claims. And we talked earlier about the difference between generic claims and specific claims and the different types of evidence you need for both. Again, for manufacturers and brands, this might be a more direct process. You're doing it on the products that you make or commission. For retailers, it's going to mean supplier due diligence. Third, once you've gathered that evidence, publish it so that the average consumer can access it. Finally, of course, Eunomia can help you with all these aspects. We're an independent voice who can help you with reviewing your current claims, policy oversight and horizon scanning. We can support putting together the evidence, so be that EU eco labels or conducting LCAs or carbon footprints. We've been around for 25 years. We're celebrating our 25th birthday this year. So we're well recognized and we're a respected voice. And we're known for our deep expertise in critical thinking. Some links here, quickly write these down. They'll never be sent again. That's a joke. They'll be sent as an email after this call to anyone who's registered. I think in particular, the ASA are a really useful guide for the UK, and it's probably relevant to other countries as well, although you wouldn't use it, you wouldn't trust it 100%, but they give, really useful guidance on how to be compliant within the rules. Otherwise, that's it. We'll move on to the Q&A, and I think Richard's been monitoring the Q&A. Hopefully we've had some Qs. I can give some A's.
Michael, thank you. That was, you kept time brilliantly, very insightful. So thank you. And yes, we do have a few questions, possibly time for one or two others if anyone else has anything that they don't feel Michael's been able to answer. Whilst you're listening to that, there's also a couple of QR codes on the screen if you'd like to sign up to our newsletter or follow us on LinkedIn. I'll take them in order actually. So Ramesh right at the start raised a really interesting question actually about we shouldn't really call this about green claims, and it should really be about sustainability or environmental. I think the regulators though actually do use the word green in a lot of their documentation. Any thoughts, Michael, around whether we're kind of stuck with green or whether it's it's fit for purpose?
I mean, it's called the Green Claims Directive, isn't it? I think that sustainability in the kind of UN sense of it is a lot broader. Like this is talking about environmental stuff. We're not talking about social. The evidence is the eco label, eco meaning environmental in that sense. So I think in common parlance, it's fit for purpose, and we got the Green Claims Directive. Whether that goes ahead or not, that is the name of it.
Yeah, great.
Still for debate.
Thanks. And then you were talking about some of the broader eco labels and contrasting that to some of the more specific claims and mechanisms that exist. And at that point, Satish asked a question about, does it impact any claims made from things like ISO 14067 around product carbon footprints? Are they no longer allowed, or do you have to use them in a slightly different way?
So I think this comes back to the specific or generic. EMCO is giving more guidance for how to make those generic claims and what backing you need for that. The same rules still apply for those specific claims. So any claim you would have made off the back of your ISO 14040, 14067 footprint LCA, the rules haven't changed for that. Ultimately, that's still a good way to back a specific claim about your product.
Yeah, great, thank you. And then a slightly different question from Greg, which is UK specific, although feels quite relevant to digital product passports actually, around, I think this is about consumer accessing the information and trying to avoid vague statements by having QR codes or website links such as is required for recycled content percentages. Are there any guidance from the ASA about how to present the information and how to be accessed?
I can't think specifically. I know there's specific laws about how big your small print can be. It's a good. again, the ASA website is really navigatable.
Yeah.
That's a word. I'd recommend looking there for specific questions about what to put on packaging.
Yeah. Okay, great. I will keep an eye on, see if any other questions come in. That's all unpicked. As I said, that I think one has. I think Ramesh is back for another question. Excellent. So if all the sales of a company are B2B, can the word average consumer be replaced with a professional customer, assuming the professional is well informed and can make educational judgments about the environmental claims? In other words, does it apply to B2C in the same way it does for B2B advertising?
So MCO and the Green Claims Code are specifically consumer protection laws. They're specifically aimed at selling to the consumer. It doesn't mean that B2B claims get a free ride. There's other kind of more generic misleading claims laws out there, but they won't have the kind of specificity of these kind of green claims amendments that you have for the business to consumer. Yeah. So it's potentially harder to navigate for companies, but also potentially less risk because there's not the kind of legal teeth to ensnare you.
That's right. Yeah, and I think that the focus and context in this is around consumer protection ultimately, isn't it? So that's where the focus is. But as you say, it's not. There's no get out of jail card for anyone. And then we just got one other question that's come in from Emily around, for example, recycled content claim. Is it clear what evidence we need to provide if we don't have third-party product certification?
Again, I'd say this comes back to the kind of focus of the webinar and the rules that have changed are on the generic claims. I would not be a good person to answer that question, but many people would. I'm sure we'll follow up on that.
We'll take that away and see if we can come back with an answer. And then with 1 minute to spare, we've had 3 new questions come in. So let me very, very quickly see if we can consolidate those. There's a question here from Andrea. So how about progressive down cascading green claims that are misleading by the selling company versus the original producer? So I think, Michael, that's a little bit about retailer versus manufacturer kind of debate. I think Cosmin, if I've got the right first name there, how should we be considered a claim such as the product contains a plastic component? So how do we have to be careful around that? And then there's a question from Peter about plastic credits and offsetting, like we buy one, remove one sort of thing. I don't know if that's covered by you. You made the point about carbon neutrality, and I guess there's an analogy there with sort of plastic offsetting, maybe.
Possibly in sentiment, but it's certainly not specifically mentioned at all, plastic offsetting, which is a really good point. On the retailer thing, I think it's interesting how, in principle, retailers have to do all this. In practice, I don't think retailers have been ruled against. So there's the case I spoke about Coke. There's a famous case about innocent smoothies the other day. In one of those cases, it's innocent that's being ruled against. It's not your Tesco and your supermarkets. So brands, retailers have to weigh up that risk.
Okay. And then the final one then was just about Cosmin asking about the product containing a plastic component, about the transparency and how that should be worded.
Interesting. It's not one I've heard before, to be honest. There's rules about how you can't show off things that are not allowed anyway. So you couldn't show off things about it not containing chemicals that are already banned by the REACH regulations, for example. In terms of, it's certainly not a specific example. You'd want to read the directive in the FAQ document clearly. I think, to make your own judgment.
Okay, Michael, thank you again for your time and wisdom on this. Really interesting. And for those that joined the webinar, thank you. And of course, those that asked questions, a special thanks as well. Hopefully we've given them a relatively reasonable answer. Do reach out to Michael or myself if you've got any specific queries that you don't feel are answered. And as you saw there, there's links there to LinkedIn and our newsletter. And I think you're going to get a copy of the recording will arrive for you to be able to review this in your own time if you wish to. But thanks very much. I hope the rest of your days go well. Take care. Bye-bye.
Thanks, everyone.